Committee on Constitutional Amendments and Revision of Codes, and the Committee on Electoral Reforms and People's Participation. This public hearing is called to order. We acknowledge the presence of Senator Laila de Lima, the chair of the Committee on Electoral Reforms and People's Participation, and the vice chair of the Committee on Constitutional Amendments and Revision of Codes and Laws. At the outset, let me acknowledge the presence of our resource persons. We have Executive Secretary Salvador Medialdea, the Honorable Aquilino Q. Pimentel Jr., a former colleague, the Honorable Vicente V. Mendoza, former Associate Justice of the Supreme Court. We also have with us, representing the local government, Mayor Edgardo Pamintuan, of the President of the League of Cities of the Philippines. We also welcome as a resource person Attorney Perry Pe, of the President of the Management Association of the Philippines, Mr. Ramon Casiple, the Executive Director of the Institute of Political and Electoral Reforms, Ms. Amina Razul, the President of the Philippine Center for Islam and Democracy. We also acknowledge the presence of the Honorable Georgie Aragon of the Department of Labor, Assistant Secretary Aragon, Attorney Wilberto Tulitol, State Counsel, Department of Justice, Maria, can I have your pangalan? Maria Elia Atienza, the Chair of the Department of Political Science of the University of the Philippine System, Ms. Angelica Sanchez, of the Executive Director of the League of Provinces of the Philippines, Adelino Sitoy, the Secretary of the Presidential Legislative Liaison Office. We expect the Honorable Antonio Natsura later. The other resource persons are not free. Secretary, former member of the CONCON, Attorney Christian Monsod, has requested that he be allowed to appear in the next hearing, as he is right now in this post. Ladies and gentlemen, today we shall discuss. There are 4 resolutions pertaining to the efforts to amend the Constitution. This is resolution of both houses number 1, calling for a constitutional convention introduced by this representation. Resolution of both houses number 2, introduced by Minority Leader Ralph Recto, which asks Congress as a constituent assembly to amend certain economic provisions of the Constitution. Joint resolution number 1, introduced by Senator Richard Gordon, proposes that Congress amend the restrictive and anti-competitive provisions of the Constitution, and Senate Bill number 128, introduced by Senator Juan Miguel Zubiri, which calls for a constitutional convention. Apart from this hearing today, the committee intends to conduct hearings in Baguio, in Cebu, and Cagayan de Oro to get as wide a spectrum as possible of our people's views. In these hearings, your committee will determine first whether or not there is a need to amend the Constitution. That's the first issue. Second, if there is such a need, what is the best mode of amending the Charter, by calling for a constitutional convention or a constituent assembly? And third, in a constituent assembly, will the two houses of Congress vote jointly or separately? And can Congress, as a legislative body, limit the powers of a constituent assembly? These are the principal issues that this committee will seek counsel from its resource persons. Let me just state on the record some of the provisions or some of the amendments which from the media reports would have interest in some quarters of our population. First, on the form of government. As we are all aware, there is a push to shift from a unitary to a federal form of government. The proponents argue that a federal system will build a just and enduring framework for peace, inclusive development, and good governance, since it requires a great deal of cooperation, moral support, and adjustments in the relation between the federal government and the states. Those who are opposed to the idea of federalism, on the other hand, argue that the federal structure will only serve to strengthen the power and political hold of local political dynasties and warlords. They also fear that a federal system will only pave the way for fragmentation of an increasingly divided nation. Another proposal is to shift from the presidential system of government, which sometimes results in a gridlock between the legislative and executive branches, and shift to a parliamentary system. Advocates for the shift to the parliamentary system tell us that these gridlocks prejudice the common good and bring about bad governance or politics of compromise. There are also those who would call for the amendment of the economic provisions of the Constitution. Those who clamor for liberalization of our economy believe that easing economic restrictions will encourage more investors and further fuel economic growth. Among others, they seek to review the nationality requirements in aid, exploration, development, and utilization of natural resources, B, the conveyance and transfer of alienable land, C, the operation of public utilities, D, ownership of educational institutions and mass media. If your committee is convinced that a constitutional amendment or revision is justified, it shall also propose the best mode to be adopted to carry out the changes, whether by Congress in a constituent assembly or in a constitutional convention to be called for the purpose. Those in favor of a constituent assembly prefer this mode because it is allegedly faster and a less expensive process. Those who support calling for a constitutional convention, on the other hand, argue that cost should not be a factor when it comes to overhauling our Constitution. A constitutional convention will allow wider participation since delegates can come from various sectors. This lessens the likelihood of control by any ruling party since the delegates will be elected in a non-partisan election. Finally, this committee must determine the manner of voting of the two houses. Copied from the amendatory provision of the Batasang Pambansa, a unicameral body, the present constitutional provision raises the question relevant to our current bicameral system, whether the Senate and the House of Representatives in a constituent assembly must vote jointly or separately. For the record, President Duterte, during the National Security Council meeting on July 27, 2016, expressed his preference for a constituent assembly and agreed to a separate voting by the Senate and the House. It must be emphasized that amendments to the Constitution is a constituent function granted by the Constitution itself only to Congress, which amendments will become effective only upon ratification by the people in a plebiscite. Can Congress, as a legislative body, limit the powers of the Constituent Assembly by specifying only which provisions can be amended, or are the powers of the Constituent Assembly plenary? To ensure that we engage the direct and active participation of our countrymen and cover the entire spectrum, we have invited representatives this morning from the academe, the business community, local government officials, civil society organizations, sectoral groups, and constitutional experts. Ladies and gentlemen, we live in very interesting times. I am sure all of us here are more than eager to step up to the plate. With that said, let us roll up our sleeves and get started. So we have requested all our resource persons to submit their position papers, and we were privileged to receive some of them earlier. So to start with, maybe we start with the executive branch, represented by Executive Secretary Salvador Panelo, to state the position. I'm sorry, Salvador Medialdea. I'm sorry. I did not mean to insult the Executive Secretary. To state the position of the executive branch. Secretary Medialdea.
Good morning, Honorable Chairman, Honorable Vice Chairman. We are in receipt of a letter dated November 16, requiring us to appear here and submit our position.
Correction, inviting you to appear here.
Yes, sir. We submit to answer for 4 issues for discussion. May we just narrate each and every issue here, Mr. Chairman. The first query is there a need to amend or revise the Constitution? We answer that the Office of the President finds the need for a revision of the Constitution in the light of his public statements on the desirability of adopting a federal form of government, among others, Mr. Chairman. What parts of the Constitution should be amended or revised? Query number 2. As to the provisions of the Constitution that may be amended, we would like to invite the attention of the committee that the President has issued the other day an executive order creating the Committee for Consultative Study of the Constitution, Your Honor. Basically, it's a consultative committee to review the 1987 Constitution, to be composed of 25 selected individuals whose name will be later on submitted. On the third issue, on the third query as to the manner of holding the amendment, if by constitutional convention or by Congress itself, the President has posited during that National Security Council meeting that he would prefer that it be done through a constitutional commission, because he believes that
Can you say that again?
the constitutional, the mode of doing it should be through the constitutional assembly, Mr. Chairman. I'm sorry. Okay.
Yes.
And citing efficiency, cost, and credibility of results, And as to the matter of voting, we confirmed that during that meeting, he said that he believes that both houses should vote separately, but we would require further legal study to determine the intent of the framers of the Constitution. Those are the positions of the Office of the President on the matter, Mr. President.
Thank you, Secretary Minjaldaya. Do you have a copy of the EO that the President has signed?
I understand it was.
Sorry?
I have a copy, but the official one will be released today or this afternoon, sir.
As long as you deliver it to us, so we consider that as the
We
official
will,
copy.
sir. Yes, sir.
So if the Secretary can secure, you can leave it to the Secretary.
Yes, we would like to furnish the committee
Yes.
a copy of the.
Yes, please. Thank you very much. This is a study group formed
Yes,
by the President.
Yes, Mr. Chairman.
This is a 25-man study group.
Yes,
Is there any indication in the executive order when the study group will submit its research paper, its paper?
well, they have set, it has set a deadline of 6 months, no, to present it for,
6 months from the constitution of the body.
from the constitution of the body.
Mr.
The
Chair,
body,
Yes.
yes, ma'am.
what is the exact mandate and the scope of that study group? To study the mode, to study the need, to study which would be the
Yes,
coverage also of the changes in the Constitution?
as to the mode, the Office of the President has expressed his preference for a constitutional amendment, constitutional assembly, yes, ma'am.
What is left to be studied by that study group?
Are the particular provisions which are to be amended. Among those is the change to a federal form of government, Mr. Chairman.
I assume regardless of the mode that will be decided upon on the amendment to the Constitution, this study will be submitted to that body.
Yes, Mr. Chairman.
When do you expect Secretary Mijaldea to have this body start its work? Maybe what, in January?
Mr. Chairman, I think there is a specific instruction that names should be already be given to the Office of the President as to who would be composed of this particular committee, sir.
So there will be nominations to
Yes,
this-
from different
from
sectors.
different sectors
Yes,
of
yes, sir.
society. Okay. And they are to conduct a study on the specific provision
To be amended.
which the Office of the President feels should be amended in our Constitution.
Among other, yes, which the Office of the President may want to consider.
So other than the fact of your preference for the preference for a constituent assembly by the Office of the President, the matters of substance will be discussed in this proposed consultative commission. The matter of voting separately is a matter that, while the President expressed his views during the National Security Council meeting, he would like to be given an opportunity to study more in detail and in-depth this legal issue. Is that correct?
Yes, sir. Yes, sir.
Any other question on the executive? All right. Maybe we would like to hear at this point our former colleague, Senator Pimentel, for his views and counsel to this committee.
Thank you very much, Mr. Chairman, and distinguished member, Vice Chair Lilia de Lima. Mr. Chairman, my main interest in the matter of revising the Constitution has to do with the adoption of the federal system. And so I have, you might say, an exhaustive, if not also an exhausting presentation on the issue. But I need not bore you with the details now, Mr. Chairman, except to state that what I am trying to propose is that the Philippines should have at least 12 federal states, Mr. Chairman. 5 for Luzon, Federal State of Northern Luzon, Federal State of Central Luzon, Federal State of Southern Tagalog, Federal State of the Bicol area, and Federal State of the Cordilleras. And for the Visayas, Mr. Chairman, 4 Federal State of Eastern Visayas, Federal State of Central Visayas, Federal State of Western Visayas, your area, Mr. President. And the 4th one, I have to make a little pitch for it, because the 4th one, Mr. President, forgive me for saying so, that I think that some imperialist thinkers in Manila believe that this 4th area that I am considering as the 4th federal state of the Visayas is part of Luzon. And I am referring to the 2 Mindoro provinces, Palawan, Romblon, and Masbate, and Marinduque. Why should this be considered a part of Luzon when these are located in the Visayan Seas? And so this will be the 4th federal state of the Visayas. And in Mindanao, Mr. President, federal state of Northern Mindanao, from the tip of Zamboanga all the way up to Surigao, which is a fairly large stretch of land, which may be divided into 2, but for purposes of our discussion, we're only saying 1 federal state of Northern Mindanao. The second is the federal state of Southern Mindanao, where Davao, Cotabato, etc. are located. And the third, to my mind, Mr. President, a very important one, is the federal state of the Bangsamoro. Unless we come up with the federal state of the Bangsamoro, the shooting war in Mindanao, Mr. President, will continue. Up to today, even as we talk, there are ambuscades being staged in many parts of Mindanao, and all because, the culture and tradition of the Muslim people are not fully respected by the majority of our people, even as of today. And so, to make a long story short, Mr. Chairman, that would be the configuration of the federal states that I am proposing. And on the side, I want to make off record also, Mr. Chairman, that we should consider Sabah as a part of the Republic of the Philippines. Very often, Mr. President, when we look at the map of the Philippines, we talk only about Luzon, Visayas, and Mindanao. And yet, as a matter of fact, Sabah is ours, Mr. President. And that goes back all the way to the time of the Sultan of Brunei asking the help of his cousin, the Sultan of Sulu, to repel their enemies, Mr. President, centuries back. When they were able to repel their enemies, the Sultan of Brunei gave Sabah as a reward to the Sultan of Sulu. And through the years, Mr. President, the heirs of the Sultan of Sulu asserted their ownership over that parcel of land. As a matter of fact, when there was an enterprising businessman, Baron Overbeck, and his partner, business partner. I want to clarify what I mean by partner, Mr. President, because nowadays partners are different connotation. But Baron Overbeck had a partner, Mr. Dent, and they both went to the Sultan of Brunei, the Sultan of Sulu, asking permission to develop, what's this, Sabah. To make a long story short, a lease agreement was entered into by the Sultan of Sulu with the Baron Overbeck and his business partner. And they call that agreement, Mr. Chairman, pajak in the Malay language, meaning to say a lease agreement whereby what's his name, Baron Overbeck and his business partner would develop Sabah, but upon payment of, at that time, Mr. President, $75,000 a year. A year for the entire Sabah, Mr. President. But in any event, over the years, the Baron Overbeck continued to pay the Sultan of Sulu and his heirs. And as a matter of fact, Mr. Chairman, let me just say that the complication arose when at some point Baron Overbeck and his business partner surrendered their lease agreement over Sabah, not to the Sultan of Sulu, but to the British Empire, Mr. President. And when Malaysia became independent in 1948, the British government also surrendered the agreement to the to the Malaysian government, laying the basis for Malaysia's claim over Sabah today. But to make a long story short, Mr. President, what I'm trying to say, let us keep it in mind that Sabah is a part of the Republic of the Philippines, and there are documentary evidences which can stand the test of United Nations, the institutions of the United Nations that would cover such controversies, Mr. President. So, let me just say also that in our proposal to adopt a federal system, the President and the Vice President will still be elected by the nation at large. But our proposal is they should be elected as a tandem, because I think that over the years, and I'm not referring to Vice President Lenny and President Digong today, over the years, you know that, Mr. President, that when the President and the Vice President come from different parties, upon election, controversies begin to arise.
And one is not allowed to attend cabinet meetings.
Pardon?
Sometimes the vice president is not allowed to attend cabinet meetings.
Correct. And that would arise usually also from the fact that the vice president, if he or she comes from another party, upon election, will be saying a lot of novenas, kailan ba mamatay itong lokong ito para ako na magiging presidente. But kidding aside, the election of president and vice president should be retained as one. Now, regarding the Senate, Mr. President, incidentally, the congressman will be, there's no change, elected by district. The senators, however, Mr. President, I would like to suggest that the senators should be elected by federal state to ensure that every part of this republic will be duly represented in the Senate. In the last elections, Mr. President, only you, coming from the Visayas, only Senate President Relon was elected senator. Nobody was elected to represent Eastern Visayas, Central Visayas, and Mindoro, the Mindoro provinces that I had adverted to earlier. And in Mindanao, only Mick Subiri and Senator Pacquiao. The rest of Mindanao. Huh? Last election. Last election. So, I am suggesting that the senators, therefore, should be elected by federal state, so that we ensure that all parts of this republic will be duly represented in the upper chamber of our legislature. And in this regard, I am also suggesting that we should have 6 senators per federal state. So, 6 times 12, that's how many? 72 already. And the normal reactions, yung dami naman yun. But Mr. President, I will submit to you later on a study that I made where nations which have fewer population have bigger representation in their upper chamber. And I'd like to advert to the fact that the 24 number of senators that we have today was based on the population of the Philippines at the time of Quezon and Osmeña, when we were only about 18 to 20 million. But now, sobrang palaanak ang Pilipino, we are now 104 million people, Mr. President. And so, just to fast-track this statement, I want to advert to the fact that the United Kingdom has 6.60 million people, and they have 797 members of the upper chamber. While we have 104 million people, we only have 24. France, 64 million people, 348 members of the upper chamber. And the Philippines only 24. Italy, 59 million, 315 senators. Spain, 46 million, 266. Thailand, 68 million, 150. And this is based on the recent constitutional revision that they had. While we have only 24. Australia, which has more, I think, sheep than people, Australia has 24.31 million people. They have 76 senators. We 104, we only have 24. Malaysia, 30 million people, 70 senators, Mr. Chairman. And so there is a basis to say that we should increase. And add more to the point, if you elect the senators by federal state, the people would know their capacities. They would know them more intimately, and therefore would be prepared to elect qualified people to the positions that we are seeking. So, Mr. President, what else? On the judiciary, Mr. President, the effect of our proposal to adopt the federal system is that there shall still be one Supreme Court. But what we are saying is that the Court of Appeals, which to my understanding, they have about 30 divisions, and there are only some divisions in Cebu and other divisions in Cagayan de Oro. But the rest of the country have no representation from the various courts of appeal. By distributing the courts of appeal to the various federal states, Mr. President, we assure that our people will have easy access to the jurisdictions defined by law regarding matters of controversy among the citizens, and thereby hopefully ensure the fast delivery of justice in this country. Because, Mr. President, if you will notice, one of the biggest problems of this country is the fact that justice is very slowly delivered. And just to cite to you an example, today I'm supposed to go to the RTC in Regional Trial Court here in Manila, attending to the case of the killing of the son of Pistaño. And that happened, more than 20 years ago. And do you know, Mr. President, that up to now we're still having a trial at regional trial court level. So, one of the things that we want to do is to introduce, Mr. President, in the revision of our Constitution, when we adopt the federal system, that deadlines for decisions must be specified. In other words, we should not allow the Supreme Court to, you file a case, okay, but when we decided, that's up to us. There should be specific limitations, Mr. President. And in my recollection, I'll give you a more detailed documentary replica of what I'm trying to say. The decisions of the Supreme Court should be issued 2 years from filing, Mr. President. We should not allow the Supreme Court to sit on the cases that are pending before them. Otherwise, delivery of justice, which is guaranteed by the Constitution, will be put to naught. So, Court of Appeals, 1.8 months. Regional, Sandigan Bayan also 1.8 months. Regional Trial Court, 1.6 months. City Court and Municipal Court, 1 year, or something like that. But there should be specific time frames within which they should decide. Otherwise, as I said, Mr. President, the guarantee about speedy delivery of justice will just be a mockery as it is today. So, what else do I want to say? Okay. On the matter of revising the Constitution, Mr. President, the best way really is through a constitutional convention, because this is where the people will have a chance to, express their own selves regarding what matters would be decided or would be revised in the Constitution. But if what the preference of the President now seems to be is to be followed, which is a Constituent Assembly, then let it be. The important thing is that, as the Senate President himself has already indicated, the committee would be conducting public hearings in various places. You name 4 areas, Mr. President, and I would suggest that much more areas be covered, so that when the hearings are conducted there, at least the people will have a chance to ventilate their own views. Now, on the issue of deliberations, whether jointly or separately, my point of view is that deliberations should be done jointly, but voting should be done separately, so that the 24 number of senators will not be swallowed by the 200 plus members of the House of Representatives, Mr. President. So yun na lang siguro, Mr. President. Salamat for this opportunity.
Thank you, Senator Nene. Laila, would you have questions?
Yes, thank you, Mr. Chair. Wouldn't the proposal of the very distinguished resource speaker for the inclusion of the Saba issue into the issue of federalism would further complicate the discourse and the entire process?
Madam Chair, Vice Chair, no, the thing is that if we add the issue of Sabah to the configuration of the Philippines as part of the Republic, it will probably be a more complicated one. Because certainly we do not expect Malaysia to just keep quiet about it. And my understanding, however, is that one of the reasons why Sabah has been put on the side of, the definition of our national territory is the fact that, for example, under the presidency of Noynoy Aquino, uh, they were using the Malaysians as the broker for peace. And therefore, there was, I think they would have felt awkward, to say the least, to, you know, insist on defining Sabah as a part of the Philippines when it is actively being claimed by Malaysia. So, how do we resolve that issue? Well, we have to use the, you might say, the institutions of the United Nations, especially those relating to the Convention of the Law of the Sea, and get them to apply wherever possible. But let us not forget that Sabah is ours, because otherwise the tendency of the millennials will be to forget that, you know, that the Philippines is only this part, Luzon, Visayas, and Mindanao, period. Forgetting that Sabah is ours, and even its Scarborough.
Certainly such posturing of the very distinguished former senator evokes or evinces a very high sense of nationalism and patriotism, you know, to really, you know, to propagate or perpetuate the position, the collective position of the country that Sabah ought to be considered as ours. But insofar as the issue of federalism, there is of course very serious reservation about including such discourse, including such a proposed course of action, because it will certainly not only complicate but further delay the process. But having said that, Mr. Chair, in as much as we're now tackling the issue of federalism, and I would not know yet who among the other resource speakers present today are also pro-federalism. But for proper perspective, because I have yet to come up with my own position on federalism, on the issue of whether it's CONAS or CON, my personal stand, my firm personal stand is for constitutional convention. Although I am open to arguments in favor of CONAS, but cannot as yet make a definitive stand on the matter. So of course, on the issue of whether it's voting separately or jointly, I don't think any thinking senator would agree to a joint voting. Joint deliberations, yes, but certainly not joint voting, because it would turn Senate into an irrelevant institution. Now, on the federalism, for better perspective po, I would really want to understand or imagine what President Duterte's federal constitution would look like. Because I have not seen, yes, the idea of federalism has been repeatedly broached, including those, the pro-federalism advocates, but I haven't seen the details, I haven't seen the mechanics. As they say, almost always the devil is on the details. The president offers federalism as a panacea or cure-all to the country's problems. So what exactly would the president's federal constitution look like? Several questions may be raised on Duterte's proposed federal setup. But the most important is what specific powers are left to the federal government, considering that in a federal setup, powers that are not expressly assigned are presumed to be reserved for the states and provinces. Is that correct? Unlike in a unitary system where the presumption is always in favor of the national government. I'm throwing out these questions. I'm not sure whether all of this can be discussed during this public hearing, but this can be subject matter of written submissions from any, from any, some, or all of the invited resource persons. So specifically, this would be the questions. Will the states or the provinces have power to determine their own laws and policies that are otherwise national in scope, example, civil, criminal law, environment, etc. Of course, on the matter of the judiciary or the judicial system that was articulated upon already by Senator Pimentel. Now, will the Philippines be a country where the death penalty is implemented in one state or province and abolished in the other, assuming the death penalty would be reimposed by Congress?
May I?
I hope not, because I am definitely anti-death penalty. Can I first throw, sir, my questions for your consideration? You may or may not answer these questions now. Now, how will environmental management be addressed in ecosystems that traverse state or provincial boundaries? Shall national parks and protected areas remain under federal management? What will be the impact of the decentralization of such policy formulation on a small nation state, such as the Philippines? We are composed of thousands of islands, but certainly we are a small nation state. What are the assurances that the rigidity of policy change identified with the federal setup will not hamper poverty alleviation programs of the national government, considering that under a federal setup, poverty alleviation will most probably be mainly a state or a provincial concern rather than a federal obligation? And what is the impact of federalism on political warlords and political patronage that characterize local Philippine politics? Will federalism exacerbate the patronage system, or will it eliminate it? How will federalism eliminate warlordism and private armies in the countrysides? How will federalism expand the democratic base for politics in localities where political dynasties control a huge patronage of the local economy? What will Duterte's federalism add to the powers of local government and autonomous regions already provided in existing laws? What are the dynamics in power relations between the national government and states and provinces that will change beyond what is already provided under the local government code and the autonomous acts, or even the BBL, if it will be reinstated or restored, or any version of the BBL will be considered? Because anti-federalism advocates are insisting that it's just a matter of putting in the right amendments to the local government code instead of going through the extreme change or turn into federalism. How will the federalism achieve what decentralization and devolution under the local government code and the autonomous acts have not? So those are just some of the questions that I want to throw into the table for me to be able to be convinced, or for me to be convinced about the merits and the beauty of federalism, because as I mentioned, I have not decided yet on this matter. Thank you, Mr. Chair, for the opportunity to raise some thoughts.
Maybe Senator Pimentel can briefly respond in general
Yes.
to the concerns. We need not go into the very specific answers, given the fact that many of these can be threshed out if we either have a con-us or a con-con. So maybe very briefly, Senator Pimentel can respond to the queries of my colleague.
Thank you, Mr. Chairman. I'd like to point out the fact that under the proposed federal setup that we are discussing, incidentally, I have not talked to the President about this. He's busy with so many things, and we never had a chance to talk. But essentially, we are one that there should be a federal system adopted in this republic. Now, on the issue, Mr. President, of political dynasties, let me say that accompanying this proposal to adopt a federal system is the power of the state to maintain only one armed forces of the Philippines, which will be used to crush any political dynasties that will try to subvert the intention of the Constitution for a more democratic way of life in any part of the country. And therefore, with one armed forces of the Philippines, that would guarantee that any political dynasty being emerging in any of the federal state will be crushed accordingly, because that would be what do you call it? That would be repugnant to the intention of having a democratic republic under a federal system of government. Also, Mr. President, there should be only one national police. Why? So that national laws on crime will be enforced by one national police regardless of the boundaries of the federal states. In other words, if a criminal in Cebu commits homicide, he cannot just fly to the Cordilleras and say, I'm in another federal state, therefore you cannot touch me anymore. No, sir. Even if we are a federal state, there will be one enforcement of national laws regarding crimes, Mr. President. So, also, there shall be one monetary system. Because otherwise, if every federal state will have its own money, I mean, it will be difficult for us, for all of us to transact business in the country. One flag, Mr. President, unlike the U.S., where every federal state has its own flag. We will only have one flag, so we will salute only one flag throughout the country, Mr. President. Then, one foreign policy. Because we cannot have federal states having foreign policies, with other countries in relation to state, you might say, state relationships, Mr. President. But there should only be one curriculum, Mr. President. Because if you are a resident of Negros and you want to transfer your family and you have a 2-year-old boy in Negros, he should be, that son or daughter should be admitted in other parts of the country, even if you happen to go to another federal state. But in the matter of investments, Mr. President, investments should be left to the definition of the federal states concerned of what is good for them, for their locality, so that they can provide work for their people. So these are some of the ideas that we are trying to propose.
Yes, thank you very much, Senator Pimentel. And obviously, I see and in an actual hearing on what should be amended, there will be a very lively and spirited discussion on these topics. Just one more item before I go to Justice Mendoza. Senator Pimentel, one of the fears raised in public in opening the Constitution to amendments is that many of the progressive, good provisions of the Constitution can be amended. And given the various interest groups all over our country, the fear that we may come up with a Constitution which may not represent our people is always raised. Question: can Congress, as a legislature, limit the powers of a constituent assembly or a constitutional convention? What is the view of Senator Pimentel on that? Limitation on the power of either a constituent assembly or a CONCON on the items that can be amended in the Constitution.
The problem is that, Mr. President, once the Constituent Assembly begins its functions, it acquires a
Plenary.
sovereign status of itself that you cannot interfere with. It becomes,
The powers are plenary.
more or less, Mr. President.
So that in your view, we cannot, as a legislature, when we convert ourselves into a Constituent Assembly limit the powers of the Constituent Assembly to review only specific provisions of the Constitution?
Unless the very law or the very resolution authorizing the Constituent Assembly would probably define the scope of the authority of that assembly.
So, all right, that's
That's
very
a
important.
possibility.
That's a very important legal issue. You are saying, Mr. Senator, that the Congress, as a legislative body, can define the areas or which the Constituent Assembly would have the power to amend or propose amendments versus a plenary power of the Constituent Assembly.
Yes, through the resolution.
Yes, through the resolution. Through the resolution,
Yes.
when we pass the resolution.
I think so, Mr. President.
Thank you very much, Senator Pimentel. Unless Senator Laila would have other questions, maybe we can go first to Justice Mendoza, and then we can go back to the others.
Just at that point,
Yes.
Mr. Chair, the same point as you raised. So that equally applies if what we would have would be a constitutional convention, that it would also be restricted on the very scope, because that's one argument against a constitutional convention. Some experts would say that if it's a constitutional convention, then it would be opening the entire Constitution into for change, for revision. An overhaul would be quite possible if it is a constitutional convention. So I think the very first issue to tackle is, do we really need to change the Constitution? But of course, for the pro-federalism advocates, certainly there's a need. But as to the exact scope, will there be other provisions? Because under this EO, creating a consultative committee, it is a study, well, that committee is being tasked to study, conduct consultations, and review the provisions of the 1987 Constitution, including, but not limited to, the provisions on the structure and powers of the government, local governance, and economic policies. So the thrust or the direction is for a total overhaul of the Constitution, because it seems it's not limiting itself. The study being assigned or being directed by the President to this consultative committee is with respect to not only the structure and powers of government, meaning federalism, but also local governance and economic policies. The list is not, or the enumeration is not exclusive. So this would probably apply to both CONCON or CONAS, to either CONCON or CONAS, whatever would be the final mode.
Madam Senator, I don't think that when this executive order was crafted, there was a contemplation of limiting the powers. The issue is not addressed in this particular EO. In fact, it's just a consultative committee which will study the substantive aspects of the Constitution. The very technical issue that I'm throwing to Senator Pimentel is the capacity of Congress to limit the amendments through a resolution of both houses, limit the powers of the Constituent Assembly to specific provisions or concepts like federal form. Now, the view of Senator Pimentel, for the record, is that yes, in a resolution of both houses constituting the Constituent Assembly, that is feasible. The next question, Senator Pimentel, is what about if a constitutional convention is called? Can you limit the powers of the Constitutional Convention?
I think the situation is altered substantially.
Okay.
Because now you are not talking of the elected representatives of the people doing the work of revision, but the people themselves.
Okay.
And therefore, the sovereign power of the people will have to come into play and would be less subject to restrictions on that basis, Mr. President.
All right. Thank you, Senator Pimentel. In fairness, I will not ask Secretary Medialdea on the views of the executive because I assume they would want to study this question closer. Unless Secretary Medialdea would want to express an opinion.
Well, precisely the executive order is only creating a consultative committee to study, to look at it on a holistic view. Then it's up to Congress what they would want to do afterwards.
Thank you very much. Without prejudice to going back to Senator Pimentel and pick his brain some more, may I now call on Justice Vic Mendoza for his views on the matters that we have been discussing. And yes, Justice Mendoza. For the record, Justice Mendoza submitted a very extensive position paper, which we have found very useful. And yes, Justice Mendoza.
Senator Drilon, Chairman of the Committee on Constitutional Amendments and Revision of Codes, and Senator De Lima, Chairman of the Committee on Electoral Reforms and People's Assembly Initiative. Good morning. I just want to discuss two concerns that are raised by the 4 measures that are under consideration. They're already there in the paper that I just submitted, but I'd like to highlight some of them in light of the question of the chair that were raised to Senator Pimentel. Mr. Chairman, Madam Chairman, the first concern I have is the responsibility for determining the need for constitutional change. In my paper, the gist of my paper is simply that the responsibility rests with Congress, not with any other body, but with Congress. The purpose of finding out whether the Constitution serves the enlightened interest of our people. So, I do not believe that Congress can shift that responsibility to a constitutional convention, but that the Congress must define the agenda of the constitutional convention. The question, sirs, is raised whether a constitutional convention can be asked to review the Constitution in general. My answer is yes. It can be asked to do that. But there is no law, constitutional or statutory, that would limit the subjects that a constitutional convention can discuss. But I would like to raise a warning that although its powers are plenary, just like Congress's power are plenary, since Congress has the power to call the Constitutional Convention, it can at least set forth the agenda of the Constitutional Convention. Whether the Constitutional Convention will adhere to the agenda is of very little concern. The point is there should be a focus for the work of the Constitutional Convention. Otherwise, we would have the spectacle of a runaway constitutional amendment, considering the time and the expense involved in calling a constitutional convention. That danger of a runaway constitutional convention, or you may call it a free-for-all, is a danger that should always be guarded against. But on the other hand, setting forth the agenda is not limiting the Constitutional Convention. It is only providing a focus or a direction for the work of the Constitutional Convention. So that Congress should set forth in the resolution of both houses what issue or issues Congress wants the Constitutional Convention to consider. Second point, still on the responsibility of Congress for determining constitutional change, the need for constitutional change, is an insertion simply in a resolution of both houses that the matter is being left to the Constitutional Convention or to Congress acting as a constituent assembly, such as when you say, unless otherwise provided by law. I think Congress here, as a constituent assembly, must take a stand whether it wants, for example, in these cases, whether it wants the nationality requirement or restrictions in some economic provisions to be removed or not. It should make a stand on this. If its decision is to have this removed, then by all means say so. If Congress is not very certain, my suggestion, sirs, would be appoint a study group composed of distinguished citizens of the Philippines, drawn from the field of economics, business, and law, to make a report and recommendation. And on the basis of the report and recommendation of that study group, make a stand, propose the amendments as a constituent assembly, or call a constitutional convention to consider this matter. But at least you lay it to the Constitutional Convention to consider this, because Congress, as a body tasked under the Constitution to call the Constitutional Convention, knows that that is an issue of such magnitude that Congress prepares a Constitutional Convention to discuss and decide on. In either instance, Mr. Chairman and Madam Chairman, the responsibility for determining the need for constitutional change remains with Congress. Second point that I would like to discuss is the procedure, which is very important. It's not simply a question of whether in voting the two houses of Congress should vote separately. Of course, if the two houses of Congress do not meet in joint session, but in their respective chambers, the voting will always be separate. Actually, there are two questions there: sitting and voting. How should the two houses sit? I would suggest, it's not in the Constitution, but that's my reading of the other provisions of the Constitution, that the two houses are called upon to meet in joint session assembled, as exemplified in RBH number 1. And then sitting in joint session assembled to vote separately, for the obvious reason that the Senate is a smaller body. So sit together in joint session assembled and vote separately. Whether Congress is acting as a con-us or in calling a constitutional convention. Of course, there are other issues raised by former Senator Pimentel about federalism, but I understand that's not within the agenda of the committees.
We can hear those views in order to come to a conclusion as to whether there is a need to amend the Constitution. And the position of Senator Pimentel is, yes, we have to amend the Constitution
You want to-
because the federal system is a better system for us than the present system that we have. Only to that extent.
All right, sir. All right. Well, in fact, my suggestion with respect to RBH number 1 is to specify the subjects that Congress wants the Constitutional Convention to consider. And I say, make it definite. Do you want the Constitutional Convention to consider the issue of federalism? All right, so I'll just discuss briefly, Mr. Chairman, the proposal for federalism. Let me begin by saying that the usual way by which federal systems are formed is for several independent states to come together because they need they need the organization. They are too weak separately, but put together, they think that in union there is strength. But they are previously independent states, United States, Germany also, until Adolf Hitler aggrandized power and set up a dictatorship. But after the liberation of Germany, it resumed the federal system formed out of that way. Even Malaysia was composed of several territories ruled by sultans, more or less autonomous, until they were put together and made a federal system by Britain before decolonization. Okay, so the point that I'm raising is the usual way is for independent states or territories and colonies to come together and form a federal system. But the proposal here is in the opposite historical direction. We are already one nation. When you convert the several administrative regions that we have into states, the effect is to divide this nation. For independent states coming together to form a union, federalism is a means of strength. In union, there is strength. But for a unitary system, for a nation like the Philippines, to divide itself into several states, independent of its other and independent of the national government, is, if I may say so, courting disintegration and fragmentation for what was once a nation. So the danger of division is a very real one. Number two, should that experiment fail, should the federation formed that way disintegrate, the several parts will find themselves without moorings and will be easy prey to annexation by other states. It will not be a Brexit, because Brexit is composed of previously independent states. But here, the states, so-called, cannot stand. It will take years to make them independent, which is what federalism means. Number 3, federalism in our case will mean intensifying regional differences that are existing, or create, if not encourage, regional differences where there are none. And then the danger of what you might call village dictators and village tyrants is more probable than the danger of a rise of a national dictator in a federal system formed in that way. And lastly, consider our present condition, especially our economic condition. It will take a very long time to make its region independent. How will you convert them overnight into super states, independent, that can stand on their own 2 feet? How will you get leaders trained in public policy to lead these several states? And then, of course, more than the amendment of the Constitution is the amendment of man's nature. People cannot just change habits overnight. For over 100 years, our people have lived under a single government. To set up a federal system, you will have 3 layers of government. The national government, the state governments in each of these states, and then the local governments. And then you have the citizen at the bottom. How will he feel governed by 3 governments? To prepare them for that will take years. Now, it seems to me, Mr. Chairman and Madam Chairman, that the problem really is not federalism. It is decentralization, for which a big credit can go to Senator Pimentel for the local government code. And that is because it's in the Constitution. Local autonomy is a constitutional policy. Decentralization is its principal means of promoting autonomy. The mandate is to prepare local governments for an autonomous and responsive role on the theory of decentralization. All these claims about federalism promoting the prosperity of the component states, promoting or encouraging public participation in government, or encouraging or promoting competition in order to improve the plights of the several states. All of these are really policy arguments of decentralization, not federalism. The many achievements cited in the last program celebrating the anniversary of the local government code, how were they achieved? How is it that we now have all local government officials elected by the local voters, not by the president or anybody else? How long has it been since they've been able to tax, although it is claimed it's not enough, that the share is not enough? All because of decentralization, not federalism. So it would seem to me the problem is not to amend the Constitution, but to pass legislation for a vigorous implementation of the policy on autonomy and decentralization. If you see the problem thus, you will agree that we will not need to amend the Constitution as far as the problem of federalism is concerned. And because of that, we will not have this problem of the Constitution does not provide expressly, but how will the two houses of Congress sit? How will they vote? That problem will be set aside for the real time that will be raised, but not now if it can be sidestepped. So my recommendations are summarized in the last page of my report. I'd like to repeat them before I conclude. My recommendations are for the formation or appointment of a study group composed of distinguished citizens of the Philippines, drawn from the fields of economics, law, and business, to submit a report to Congress. And Congress, whether acting as a constituent assembly or calling a constitutional convention, to be guided by the report and recommendation of this group, but always to take responsibility for determining the need for change. Number two, that RBH number 1, consistent with what I have said, specify the reasons for calling the Constitutional Convention. And I would like to repeat, that is not limiting the Constitutional Convention, but only setting forth the theme or the guideline for its discussions. Number 3,
Just on that point, Justice Mendoza, so we do not miss it. If, for example, the RBH will say, discuss the form of government in a constitutional convention, would that prevent the constitutional convention from tackling the economic issues?
that can be done, Mr. Chairman, but the better way for it to be told is, if that is the decision of the Congress, is to tell Congress to consider a proposal for a federal system, for a particular form of government, parliamentary, federalism, or whatever.
You mean let me repeat what bothers me. Following your theory, Mr. Justice, you are saying that the resolution of both houses calling for a constitutional convention can at the same time specify that, say, focus on the form of government. Just say that's what appears in the resolution of both houses. Does that prevent the Constitutional Convention from tackling the economic provisions with that specific focus stated in the resolution of both houses? Can we have that?
But
Yes.
But it is not limiting. What is prohibited is limiting the Constitutional Convention to a particular issue or issues. Like, for
Yes.
example, to discuss this issue or issues and no more.
Yes.
You're not going to say that.
Yes.
But then, on the other hand, if you do not do that, there will be a free-for-all. They will be free to discuss any matter, waste the time and the money called to ask them, and maybe it will take years if they cannot all fashion a draft of a constitution.
Well, in our proposal, conscious of that, we set the date for the ratification of the Constitution so that that is a deadline for the convention to finish its work.
I did not get that question very well.
No. We were conscious of your of the fear of a runaway constitutional convention.
Yes.
One of the issues or one of the safeguards or a safeguard we suggested is to set in the resolution of both houses the date of the ratification and in effect the budget of the Constitutional Convention so that they will finish their work, say in 2 years' time, and because the deadline for the ratification is, say, 2 years from their convocation of the convention. How does that strike the good justice?
I don't think that is feasible. I think they will disregard any limit placed on them. And then they probably will invoke a dictum of the Supreme Court that in case Congress fails to appropriate funds for the work of the Constitutional Convention, the Constitutional Convention can appropriate funds.
All right. Okay.
Supreme Court said that.
Okay. So thank you. Can you just finish your recommendations and then I give the floor
Yes.
to Secretary
But at least-
De Liva.
Setting forth the subject or subjects that Congress wants the convention to consider will provide some parameters.
All right. Yes.
They can disregard, but at least they are cabined there, canalize
Yes.
the
We
discussion.
fully. Now, is there any other recommendation that you want to expound on? Is there any other recommendation that you wish to expound on in your paper here? Or are all those recommendations?
Well, that's it with respect to the proposals to remove. It's not exactly to remove, to propose that the nationality requirement and other restrictions on some economic provisions be modified in the sense that the constitutional provisions will remain until Congress thinks otherwise. I think that is delegating to Congress as a ordinary legislative body a task or a provision of the Constitution that the people, that a constitutional convention and the people have adopted, and leave it to Congress to repeal or modify that. I think that is not salutary, Mr. Chairman, because here you set forth prohibitions. You specify a 60-40% requirement, for example, or you prohibit certain economic activities and leave that exclusively to Filipinos. But then you also say, unless otherwise provided by the Congress, which is what you say by law, I think you are going to allow Congress to override or to change what is in the Constitution, which is the work not only of a constitutional convention and the people, but to Congress as a legislative body.
In other words, Mr. Justice.
There is no provision, excuse me, there is
Yeah,
no provision like that in the Constitution.
In other words, you're saying, Justice, that to insert the phrase, unless otherwise provided by law, on the restrictive provisions of the Constitution is unconstitutional because the Constitution was crafted by a commission or a convention or Congress as a constituent assembly, ratified by the people, and therefore cannot be changed by a simple legislative act, even if it is so provided in the Constitution by stating unless otherwise provided by law. That is the view that you are expounding on, Mr. Justice.
Well, I would hesitate to say that, because on the other hand, the one that puts this phrase there is a constitutional convention also. So also, that's the work of the people, see? So I cannot say that that is unconstitutional, being the act of a constitutional convention and ratified by the people in a plebiscite.
So what is your view, Mr. Justice? Can that
Well,
phrase
sound
be there?
laws, it is not sound.
It
say,
is not sound.
constitutional policy.
Okay, as a matter of policy, it is not sound.
It is not sound.
But even if it's unsound, it can be,
Technically, yes, but
technically,
not
yes.
it's going to the birds.
Okay, thank you very much. Senator De Lima, would you have any question? Yes.
Thank you, Mr. Chair. Just 2 points, just 2 issues for the good justice. Your Honor, would this be a correct postulate that a runaway, free-for-all constitutional convention would not be constitutionally objectionable? Because anyway, its output would be ratified later by the people and therefore becomes a sovereign will or an act of sovereign will.
There's no prohibition, as I was saying, legal or otherwise, from having the Constitutional Convention consider any matter in disregard of the resolution of Congress. Nothing, except their moral responsibility as delegates. But at least the subjects they are called to consider must be stated there to provide, as I said, a focus. Or a direction for their work.
So it would
But
still be
legally
desirable.
speaking,
It would still be desirable to really
yes, confining them
specify.
to, yes, that cannot be done because it is just like Congress, its powers are plenary.
Thank you. Second point, I do appreciate your argument against federalism insofar as you stated that it would in fact be courting fragmentation or disintegration because it tends to go the opposite direction historically.
Because it divides what is already a unit. We are hard putting this archipelago of 7,000 islands together. And now we are
And
going
you
to
cited-
divide this and
and-
then
and
throw
you-
them overboard.
And you cited, Your Honor, examples of the United States and Germany. And even I think Canada is also an example of that they started as independent states and then ended up as federal or go federalism. But have we studied the experience of India? Because India, it was a British colony, and then they opted for federalism when they came up with their own constitution, so as to account for, or in order to correct certain historical mistakes or historical regional differences. I think that's that's another example, but a different perspective. So it's not the same. It's not the same history as that of the United States, Germany, and even Canada. So that's the contrary example. India, to account for, in order to correct a certain historical regional differences. But just a food for thought. Salamat po.
Thank you very much. Thank you very much, Justice Mendoza. We take note of the positions and views taken by Justice Mendoza. Indeed, the responsibility of amending the Constitution is a function of Congress, as you have so clearly indicated. In any case, yes, we take into account the very learned views expressed by Justice Mendoza, and we thank him for assisting this committee in its work. May we now hear from the private sector before I go back to the academe, before I go to the academe and the local government. Attorney Perez. Attorney Perez.
Mr. Chair, may I just put in on record, I actually cited Canada earlier. I think I was mistaken. Canada did not start as federal and turned unitary. It's the other way around.
The other
Also
way around,
unitary
yes.
to federal. So it's
Yes.
only US and Germany. Thank you.
Yes. Yes, Attorney Pe.
Good morning, Your Honors, Mr. Chair, Madam Vice Chair. My name is Perry Pe. I'm the President of the Management Association of the Philippines. We're composed of about more than 1,000 CEOs, CFOs, and COOs of the country's biggest corporations, from the medium-sized to the big corporations. And if I can just summarize the 4 issues raised by the Honorable Chair. On the first issue, on whether there's a need to amend the Constitution, we, from business, we believe it's high time that we should amend the Constitution. We support it wholeheartedly, even way before we've been asking for the change in the Constitution already, specifically on the economic provisions. We're businessmen, Your Honors. We feel the need to change because the economic provisions in our Constitution simply is letting business down. Now, as to the proposal given by the various Senate resolutions or bills passed here, whether the insertion of the phrase "unless otherwise provided for by law" would be sufficient or not, we have studied it, Your Honors. We think it is too simplistic. We think it will not solve the issue. We think, as the learned Justice Mendoza also said, that it will just complicate the issue. We think that, and we believe, Your Honors, that the basic problem in our 1987 Constitution can be found in Article 2, Section 19. And if I may quote Section 19 of Article 2, it says, "The state shall develop a self-reliant and independent national economy effectively controlled by Filipinos." If you do not remove this, Your Honors, nothing will happen. Even if you insert the phrase "unless otherwise provided for by law," it will always be decided or interpreted in accordance with this Article 2, Section 19. So if we don't take this basic declaration of principle under our Constitution, nothing will happen.
What's wrong with that, Attorney Perry?
Because, Your Honor, if you want to lift all the economic restrictions, you have to necessarily take this basic principle out. Otherwise, as we can see from the Supreme Court case in the Manila Hotel, where they cited the national patrimony, they decided on a certain business case citing that basic principle. Also in the Taiwanese petrochemical case, they decided based on those 2 principles of law. So we think that that is the basic thing that should be removed. And if we remove that, then altogether we can also remove the other economic restrictions in the Constitution. Your Honor, whether the system goes federal, whether the system goes parliamentary or presidential, we in the business, we really don't care. We don't know. You're more experts than us. We just want that the economic restrictions be lifted. On the second point, Your Honor, on what is the mode of lifting, we in the business community, we're businessmen, Your Honor. We think it should be by way of a constituent assembly with recommendations or guided or support from a constitutional commission. Like Justice Mendoza, we fear of a runaway constitutional convention, aside from cost factors. This current Congress, both the Senate and the House, were elected by the people already. And the issue of federalism during the campaign was also brought out. Some people campaigned on it, some people did not. Well, the issue came out nationally, and you were voted, and you are now our representatives. And therefore, we believe that you can really act on it, and you can become the constituent assembly that we're hoping for to change our Constitution. Whether On the issue whether the Constituent Assembly should vote jointly or separately, of course, we think it should vote separately. And whether the Constituent Assembly should just have a plenary or a specific power, we think, like Justice Mendoza and and Senator Pimentel, we think that the Constituent Assembly has plenary powers, Your Honors. Summarize, Mr.
Thank you very much. Senator De Lima, would you have any questions on Attorney Pei?
A question. If I will not be convinced of the merits and the beauty of federalism, I would just opt for the amendment of the economic provisions or the lifting of certain economic restrictions. And if that is the case, then I don't think we would need a constitutional convention. We can have a constitutional assembly, provided the right issues are really identified and assisted by a council of experts or a council of consultants to focus on the economic provisions. That's how I think and feel right now, if and when I'm not convinced of the merits of federalism. Thank you.
Just a point of clarification from the chair. The view was expressed by Justice Mendoza that in a constitutional convention, the Congress, when it passes the resolution of both houses, can highlight the focus upon which the convention should concentrate on. Without prejudice, however, to the convention tackling other issues. What about Justice Mendoza in the case of a constituent assembly? Can Congress, in passing the resolution of both houses, expressly limit the powers of the constituent assembly?
The same, Mr. Chairman, it can, I suppose, it can do that, but exercising self-restraint, the members of Congress can themselves limit. After all, the call will be placed to a vote by the members of Congress. If they agree to place that in the agenda of the Constituent Assembly, I suppose they will abide by that, since they will also constitute the Constituent Assembly.
So
It's a moral limit only.
okay, just to clarify, because there will be two separate bodies, the Congress as a legislature and Congress as a constituent assembly. It is Congress as a legislature which calls the constituent assembly. Now, I can appreciate that your statement, Mr. Justice, that's a self-imposed restriction. Who will impose that restriction? The Constituent Assembly on itself, or would it be Congress when it calls for a Constituent Assembly?
Even in calling a constitutional convention, I think Congress performs not a legislative function in calling a constitutional convention. It is already acting as the agency under Article 17 to propose. It's the only agency outside of the people that can propose amendments or revision to the Constitution. Therefore, it's not acting as a legislative body. It is already acting as the agency to propose a constitutional convention. So that if it places those limits there, it is not acting as a Congress, but acting as the agency under the Constitution for calling a constitutional convention.
Thank you very much, Justice Mendoza. May we hear from the local governments represented by the President of the League of Cities, Mayor Pimentel.
Thank you, Mr. Chairman, Madam Chairman. Magandang umaga po sa inyo lahat. The cities have been brought about to have the biggest number of people living in about 40,920,000, it's 2015 census, that's about 40%, 0.53% of all people, they live in the cities. And I'd like to thank you, Mr. Chairman and Madam Chair, for inviting me. But considering the time constraint that we were invited, we received this only on the 29th. The following day is a holiday, so we have barely 4 days to discuss this among ourselves, and we just had our General Assembly and the National Executive Board. But be that as it may, we found out that there are a lot, after we have emailed them, all the mayors, to come up with their insights, their comments, and possible recommendations, being the mayors of their respective cities. And we were able to call some opinions, and perhaps if given enough time, and we really would not want to give them deadlines, but as of last night, we have about 25 cities who have submitted their comments. And if I may, this will only take me about 10 minutes, and then we will come up with the official statement later on, and we'll be submitting it probably within next week, Mr. Chairman, Madam Chair. Yes, the League of Cities of the Philippines believes it is time to revisit, review, and amend the 1987 Constitution. We also think that we amend not only the economic provisions, but its entirety. The review and amendment should not be piecemeal. And I was just making an animated discussion with my former boss at the Office of the Solicitor General. I feel like I'm just a caged bird in the House, given the title of the eagle of the constitutional law when I was still with the Office of the Solicitor General, when he was a member of the Supreme Court. And I'm happy that he's a kabalan. And please be patient with me. Malit na pipit lang po ako compared to the eagles and the lions of laws here. The 1987 Constitution, to be sure, has served its purpose well, particularly upholding our democratic and human rights. This is about 30 years ago. That was after martial law. But there are many new challenges and developments that must be confronted and addressed, which may be beyond the ambit of the current basic laws. The League of Cities supports the move towards conversion of our system of government from presidential unitary to federal system. We believe the federal system will provide for genuine and greater autonomy to the regions and the local governments. There are some who are saying we're not ready, especially those poorer cities, poorer towns, poorer provinces, poorer regions. But given the perspective of allowing us to retain 8% of the revenues and giving only 20% to the national coffers, I think we will be given that much impetus to generate more economic development in our region. And for the smaller regions, they can get as much as they want from the 20% each that the different regions and states will be delivering to the national coffers. There will be no more, of course, the Imperial Manila that lords over the allocation of our national resources. That ironically come from the regions. We give more, but we get less. But on the part of the city of Angeles, I'm very proud to say that we are not that reliant anymore to IRA. Because when I took over in 2010, my budget was only 800 million to include IRA and local revenues. Now I have 1.7 billion. That's because of perhaps political will. I really make total increase of valuation real taxes. Anyway,
What's the ratio between your IRA
Before it
and your
used to be
locally
60-40.
generated funds?
it used to be 60-40, Mr. Chair. Now it's the other way around.
60% locally
Before
generated?
it used to be 60% IRA and 40% local. Now we turn it around. And I still maintain that it should be the Department of Finance who will do the evaluation at the mayors, because when I saw the shame campaign in the Department of Finance, only the city of Angeles made some increases in 1995 when I was mayor, and again in 2012 when I was again the mayor. No mayors except Manila did some revaluation and assessment on the real property tax. A case in point is that while regional development is tackled in the Regional Development Council, we still need to pass through many review and approval processes from the national government. In many instances, we need to lobby with concerned national agencies. And napakahirap po dadaanan namin lahat. They're really circuitous. We think that the states or autonomous regions under the federal system of government will be able to develop and implement big projects without too many hands and heads that complicate the delay, the decision-making and action. We all know that corruption occurs when too many hands are deep into the project. And of course, we feel that what we're doing now, going towards federalism, Your Honors, devolution, yes, I attended this step 2 in Germany right after the approval of the local government code. And devolution, decentralization, then later on devolution, then you have this BUB projects. I think these are precursor towards federalism. Palagay ko po, papunta na tayo talaga sa federalism. I mean, this is just my personal contention, ma'am. Sir, sa akin lang ito. I think these are precursors. The decentralization from the local government code, and then devolution. The projects now are BUB from the bottom up. We think that the states or autonomous regions under the federal system of government will be able to develop big projects, as I've mentioned before. And on particular note, we also bat for longer terms of elective officials. Sana tanggalin po sa Constitution yung limitation, because this is a product of martial law. They limited the local government term to 3 years. After 1 year, second year, nagpe-prepare ka na ng election. I think the better term is give us 3, but give us 5 years or 3 years or 4 years. Napakahirap po talaga. And all politicians are gearing to election after 1 year. So you only have 1 more year to prepare your city. Election na naman. On a particular note, of course, as I've mentioned, from the Constitution, ilagay po natin sa local government code yan, para hindi mahirap magpalit-palit ng taon. 3 years are too short for a good local executive who may be forced to immediately engage in various ways of politicking and patronage politics just to ensure a next term. And as to how many years should be added to the terms of local officials, we would leave it to the Constitutional Assembly. As to whether the process of forming the Constitutional Assembly, either by popular election or converting Congresses into a constituent assembly, we submit that we consult our people by way of an inclusive and extensive survey targeting a good number of respondents and conducted by truly independent and reputable groups. Thank you very much, Mr.
So we even consult our people on whether or not we call a constitutional convention or convert ourselves into a constituent assembly. Is that what the position is?
This is just from the 25 cities, Mr. Chairman. What we need right now is really to get a real good, honest-to-goodness survey, because kung tayo po rito ay hindi nagkakaisa, what more yung mga individual ordinary laymen, they don't understand anything about this. Of course, there are people and groups that go around addressing the problem of how to go about doing some constitutional reforms. Most often than not, they would rather take their lunch and then they leave. They don't know anything about this. Then, as leaders, Mr. Chairman, we feel we should get really a survey, and this should be done as soon as possible.
Thank you very much. We just note the fact that before this amendment can be effective, it will be voted upon by the people in a ratification. So anyway, we hear the president of the League of Cities, and we will take that into account when we finally submit our recommendation to plenary.
Thank you,
May,
Mr. Chairman.
may we now hear from the civil society? We start with the executive director of the Institute for Political and Electoral Reforms, Mr. Ramon Casiple. You have the floor.
Thank you, Mr. Chair. We just have a short answer to your questions. Number one, we have always supported the revision of the 1987 Constitution. We know it was hurriedly done. There are a lot of loopholes. There are exactly 55 provisions that require enabling laws, which we think is a problem with the Constitution. And the Constitution itself provides every 5 years for a review. That has not been done. It is now 30 years. There are a lot of things that happened: globalization, climate change. We now have 6 presidents. There are new situations that have arisen nationally and internationally, which we think the 1987 Constitution does not address quite well, including the economic provisions and so on. So our position here is for revision, not merely amendment. To the second question, because it's a revision, we think all the parts should be reviewed. With regards to the manner of the change, we are apprehensive about the Constituent Assembly approach to revise a constitution. Amendment, yes, that has been done in the past, but it is only the 1987 Constitution which actually provided for revision of a constitution by Congress. This is an untested waters, actually, Mr. Chair. And there is a question here that vested interests may come in because, one, Congress legislators were not exactly voted upon by the people to change the Constitution in its entirety. And second, we know already the opposition that by the people every time there is that particular manner being proposed. And I don't think this will change, Mr. Chair. It's better to start off on revising the Constitution with as many of us among the people agreeing on the manner, rather than insisting on the legal powers provided by the Constitution for Congress to change it. What I mean here is that we should have a national consensus on how to change the Constitution and what to change in the Constitution, rather than I wouldn't say this word, it's very strong, rather than railroad it without any consultation. To this point, we add the argument that the revision is a move or is an activity by the people, Mr. Chair. It's not for representatives of the people. That's why there is a need for ratification. So there is, I think, that need for consultation and maybe the opportunity for the people to decide whom they want to change the Constitution. And that can only be done through a constitutional convention by electing delegates directly by the people. The only additional point that we are open is the appointment of the best minds of the country to that constitutional convention in order for them to contribute with regards the content of the change. My last point, Mr. Chair, is about the proposal for federalism. And I appreciate actually the points already made that the federal proposal or the system itself is usually coming from a situation of separate independent states uniting for a federal unified state. But recent examples actually are already here, like Belgium and Spain, where a unitary system became a federal system due to the specific national requirements of strengthening the national unity of the people by recognizing the differences that actually exist. In the Belgian case, it's the Wallons against the Flemish peoples, which had became a joke actually in that country. But they approached it in a way that there was respect for its people, and that became the basis of the federal state there. In Spain, there is a question of the rebellion of the Basque people, and the national as against the national consensus for staying as a unified state. So the proposal for the federalism there was actually part of the proposal from the Spanish national level to the Basque rebels. And the way they proposed was the creation of the Catalan state based on that proposal. Of course, the Basque rebels have not yet accepted the whole concept, but that was supposed to be a proposal addressing the rebellion. In our case, it has already been made as part of the argument in approaching the Moro rebellion. We support that actually, if we can have the national consensus first on that particular point of a solution to the rebellion. Because if our Muslim brothers and sisters accept that, then that may solve the rebellion. And we're open to that. But we also caution against adopting simply a federal system, because we don't think that federal or unitary system is bad or good per se. It's really the question of details. What is the exact form that the federal proposal takes place in the Philippines? We have been part of study groups here, and I would like to cite one example that I think should be addressed by a Constituent Assembly or a Constitutional Convention, and that is the nature of the local states. The classical federalism has a feature which is crucial to that classical federalism, which is called shared sovereignty. Meaning, when independent states decide to federalize, they retain their particular sovereign powers. That includes the power or to declare independence if they think the union is not really good. In fact, that became the basis for the American Civil War. In the modern, or I don't know if I can call it modern, but in the case of Belgium or Spain, the reverse is the situation. There was the insistence from the start when they federalized not to have that shared sovereignty as part of the concept. Meaning, those who made the decision to federalize set aside the shared sovereignty concept from the start. So the question of independence or fragmentizing a unified state is already out of the question from the start. There are proposals now, in our case, along those lines, and we hope that could contribute to the discussion. But at this point in time, what we would like is a national discussion on federalism, not simply an assertion that we should federalize, because that decision, I think, should be a national decision, a decision by the whole people. It could not be decided by legislators alone. Meaning, ratification is not only the participation, I think, that is required of the people. It's the prior discussion. Before
The
even-
prior discussion precisely takes place in committee hearings, either in Congress, in the Constituent Assembly, or in the Constitutional Convention.
in all forums, Mr. Chair, media, local.
It doesn't prevent media from expressing its views as it does.
Yeah,
So,
I agree with you.
I'm trying to figure out what you mean by a national discussion other than a ratification.
What I mean, Mr. Chair, is that we draw the stakeholders into the discussion.
Right.
Not only as observers or
Yeah,
audience.
well, precisely. This is the only process, this is a process, amending the Constitution is a process where the people would directly participate through a ratification process. We cannot have a situation where you gather, I don't know how many millions Filipinos and try to get their views on an amendment. You have to go through your representatives, whether they are CON representatives or CON-AS representatives. They have to go through we are a representative government, and therefore they express their views through committees like what we are doing today.
Yes, I would agree with that,
Yes.
Mr. Chair. In fact, that would be the focus of
Yes.
the national discussion, I think.
Yes.
And I end my
No,
presentation.
just a few points. You mentioned, I was surprised that, you said that every 5 years this Constitution must be reviewed. That's a surprise to me. I'll go back to the Constitution. What the Constitution provides is that amendments through people's initiative can be done 5 years after the ratification of this Constitution, and no amendment can be authorized more oftener than once every 5 years, where the mode is through a people's initiative. But there is no requirement that we review the Constitution every 5 years, just for clarity. Okay. So just for the record, since this is the position of Ramon, that the Constitution must be reviewed in every aspect, it is best done through a constitutional convention. But you would agree that precisely we will consult, there should be an extensive consultation through hearings like what we are conducting today, because precisely that's the nature of our system, consultative, the consultative character of our legislative system. In any case, thank you very much, Professor Casible. Ms. Razul, can we have your views?
Thank you for the invitation, Mr. Chair, Madam Chair. We at the Philippine Center for Islam and Democracy have been looking at issues of amending the Constitution for more than a decade now, often in tandem with the former Senate President Aquilino Pimentel Jr., because the citizens coming from our communities have always felt that the present unitary form of government has been, shall we say, not responsive to their needs, those who are away from Imperial Manila. So as to the first question, is there a need to amend or revise the Constitution? We at the Philippine Center for Islam and Democracy believe that it is time to revise or at least amend the 1987 Philippine Constitution. In our minds, it is not a holy book. It is neither the Quran nor the Holy Bible, which cannot be amended or revised. The late great ASEAN statesman Lee Kuan Yew compared the Constitution to an ill-fitting suit that one is given, a hand-me-down from our colonial masters. And he said it is the obligation of citizens to tailor-fit it so that it suits our physique, our build. And perhaps in the case of the Philippines, maybe we don't want a suit. Maybe what we need is a barong Tagalog. So yes, definitely, Mr. Chair, to amendment or revision, particularly since our world has radically changed, geopolitics have shifted, so we do need to have our governance and political systems more responsive to the needs and the changed interests of our people. What parts of the Constitution should be amended or revised and why? Generally, Mr. Chair, we at the PCID, and we have been in consultations with the various communities for over a decade now, we are in agreement with the positions that have been presented by our former Senate President. Generally speaking, there are some variations, but let me just say at this point that we have a big consultation on December 15, and we hope to come up with a strong position paper after that consultation, and we have invited a member of the committee to be present since we were going to be having it at Club Filipino.
Maybe you can submit the results of that meeting. We will, because we expect that
Yes.
we will still have hearings in February.
Yes, we will do that, Mr. Chair. So when we look at what needs to be amended in the Constitution, we realize that federalism is the major driver for the move to amend or revise the Constitution, where you will have sovereignty shared between a central governing authority and constituent political units that will be called states or regions, representing the issues of Muslim Mindanao, and I believe also the interests of the indigenous peoples from north to south. We are taking a look at the political solution that have been accorded Muslim Mindanao, which is an effective and genuine autonomy, a product of the 1976 peace agreement, redefined, improved by the 1996 final peace agreement, and the subject of negotiations with the MILF, resulting to the comprehensive agreement for the Bangsamoro and fleshed out in the Bangsamoro Basic Law. The Bangsamoro Basic Law would have passed if it were not for the tragic events of Mama Sapano. And having undergone the process of discussions and lobbying for the passage of the Bangsamoro Basic Law, and having listened to the framers of the Constitution who said that they did not find anything violative of the Constitution in the BBL, that it should actually be just maybe a change of the language. Looking at that, having experienced that, but still coming with the result that the Bangsamoro Basic Law was junked, those who are working on effective autonomy, a stronger foundation for democracy in Muslim Mindanao, realize that the present system really does not work for us. So we are looking at the federalist system, but the one major recommendation coming from the group is that the gains of autonomy, which is also enshrined in the 1987 Constitution, be secured, be preserved, if not strengthened. And that we take a look at the comprehensive agreement for the Bangsamoro as fleshed out in the Bangsamoro Basic Law, which finds its roots in the 1976 peace agreement. We take a look at that, and as much as possible to bring it into the proposed constitution, whether through CONAS or through CONCOM. The details of this, Mr. Chair, we will be presenting to you after the December 15 agreement. And we hope that this will finally lay to rest the issues always that were always raised during the BBL discussions about the constitutionality of the grant of autonomy. With regards to should amendments or revisions be proposed by a constitutional convention or by the Congress itself acting as a constituent assembly, generally our group believes that it should be a constitutional convention to ensure wider representation. In particular, Mr. Chair, we recommend that there be rules of engagement that would ensure gender fair representation, as well as representation of indigenous peoples of cultural communities. But more on that we will submit later. With regards to if it is a constituent assembly, should the Senate and the House of Representatives vote jointly or separately? We definitely agree with Justice Mendoza about sitting jointly and voting separately. Thank you, Mr. Chair.
Thank you, Ms. Rasul. Do you have any questions? There are none. So can we hear next from the academe, Dr. Maria Ella Atienza, the Chief of the Department of Political Science of the University of the Philippines.
Thank you very much, Mr. Chair. Ms. Chair, thank you very much, first of all, for inviting the Department of Political Science of UP to provide some views about constitutional changes in general and some of the proposed bills affecting our current constitution. Actually, the department was able to present a position paper at the public hearing of the House of Representatives Committee on Constitutional Amendments last November 16. So some of the contents of the position paper that we submitted today were also presented at the House of Representatives. But I'm not gonna read everything. I'm just gonna highlight some
Give
of
us the
these.
highlights, yes.
Yeah, some of these because of course, as scholars, we focus on a lot of models, and most of the institutional arrangements have their particular advantages and disadvantages. But what we wanted to do with the position paper is to try to highlight some important points that can be considered by the two houses of Congress when they propose either a CONAS or a constitutional convention. First, in terms of process issues, I think it's important to articulate what would be the scope of the changes that will be given to the Constitutional Convention or the Constituent Assembly. How grand are the changes being contemplated? Because this is important when we look at the history of constitution writing in the Philippines. The 1935, 1973, and the 1987 constitutions all emerged from certain historical background. So the question would be, what is his current historical background that warrants for constitutional change? Another important thing would be the issue of timing and actually the role of the people in desiring for constitutional change or constitutional reforms. I think some of the bills regarding changes in the Constitution focus on having a public clamor for the shift or the change in the constitutions. But given that the Pulse Asia July 2016 survey it actually says that 73% of Filipinos have little or no knowledge of the country's current constitution. I think it's important that the public hearings would actually engage more citizens in region so that they really are part of discussions, not only of the proposed changes, but actually a basic understanding of what we have now and what needs to be changed. On the appropriate drafting body, our position paper noted some of the dangers or drawbacks of having a constituent assembly. We noted that, of course, it is less costly, it's more economical, but the assembly may seek to advance institutional interests at the disadvantage of other institutional actors. The political parties that dominate the assembly may lack internal democratic structures. The parties may tend to favor electoral systems that may distort the distribution of representation and power. The excluded parties may resort to violence or not own the process. A more practical consideration, of course, is that the process would take time and resources away from more regular legislative responsibilities and priorities. Of course, the two Senate bills focus on having the Constitutional Convention as the mode of change. And the members of a Constitutional Convention, at least based on studies, are more focused on their job of revising the Charter because they have been elected specifically for that particular purpose. Likewise, the process through a Constitutional Convention can be more democratic, transparent, and deliberative. However, we also note in our position paper that a constitutional convention may not necessarily be more inclusive than a constituent assembly. And we say this because a case in point is the 1986 Constitutional Commission. This has produced a constitution that will now enter, or at least next year will enter its 30th year. While the current constitution has been described by critics as, of course, superfluous, it undoubtedly has very strong democratic credentials. In addition, the members of the Constitutional Commission were selected from a variety of important sectors of society who would not have necessarily won had the basis been a popular vote. Okay. So at the end of the day, choices on the appropriate mechanisms have to be made in favor of generating greater legitimacy for the constitutional reform process. We note also the importance of having deliberative and dialogical processes that involve the people. And at the same time, we also note that the constitutional reform should jive with the ongoing peace processes. Stakeholders in the peace tracks need to be shown how the substance and time frame of the constitutional reform initiative taken on by the administration and the two houses of Congress will support and not supplant the political settlements arrived at through the negotiations. At the same time also, there is the based on the comprehensive agreement on the Bangsamoro, there is the urgency to legislate Bangsamoro basic law. In terms of the proposal to federalize, of course, based on our studies, there are specific reasons why federalism is appropriate to deal with specific conditions or problems of a particular society. However, we listed down in the position paper a number of possible limitations, and this is based on the experiences of countries that have actually federalized. And it's important to note them and probably learning from the experiences of other countries that have federalized, perhaps how can we make a possible federal Philippines resistant to some of these problems. A possible limitation would be, of course, creating regional discrepancies, continued dependency of lesser income states on the federal government, and possible resentment of the more affluent regional or state governments. Another limitation would be possibilities of disparity in the provision and the quality of public services across the proposed states. The lack of coordination and cooperation and possible government paralysis and gridlock, the need for more budgetary requirements to create an additional level of government. There is also additional problems in terms of continuing challenges to nation building and national identity that are being experienced even by the most developed federal systems. For instance, in Canada, the Quebec case is a particular example of the continuing desire of certain segments to still separate. And the Belgian case, while of course Belgium came late in shifting to a federal setup, the French-speaking part and the Dutch-speaking part still cannot consider themselves as one united country. it's also necessary to think about how federalism can avoid monopoly and abuse of power at the local levels. The last part of our position paper is actually a list of possible amendments versus actually revising the entire Constitution, because our questions are, could we instead envision an evolutionary transformation of our institutions? Specifically, could the perceived problems of our current national milieu be addressed instead through several constitutional amendments, regular legislation, or executive action? We draw particular attention on Article 10 of the 1987 Constitution. Could the underdevelopment and relative deprivation of peripheral states and the lack of governance and fiscal powers of subnational entities be addressed by amending Article 10 of the 1987 Constitution and legislating a new local government code as well as organic acts for autonomous regions as may be deemed necessary? It's also possible, can the option to constitute themselves into autonomous regions be given to other provinces, municipalities, and cities and geographic areas? Can regional development councils and metropolitan political subdivisions be vested with more developed powers? It's also possible to focus on federalism, but it focus on the more asymmetrical arrangements as is being done in the Spanish model. We are also recommending a number of smaller amendments, possibly in the form of creating regional-based constituencies instead of national constituencies for the Senate, holding of a runoff election for presidents, reviewing the terms of elective positions and term limits of local government officials, reserving certain legislative powers for the lower house so as not to give more attention to pressing issues of local concern, and instituting a constitutional court that would hear cases pertaining to constitutionality so as not to overburden the Supreme Court. And we also have a list of some possible amendments to the current local government code. So our list is not really exhaustive, but our intent is actually to stimulate some alternative thinking and generate some more possible or practical solutions in terms of actually amending our Constitution. Thank you very much.
Thank you, Professor Atienza. There are no questions from the other senators. May we hear from Secretary Sitoy?
Thank you, Mr. Chair, Madam Vice Chair. I have some suggestions on the proposal of Senator Nene. Now, first, we have to go federal in view of the proposal to reverse the proportion of income in favor of the federal states and lesser income for the national. And it seems that the proposal to create 12 estados would be very bulky. And in the light of the apprehension that some estado might acquire secessionist thinking, perhaps we can reduce the size of the estado to a province, for example, of no less than 1 million population. And then we come up with the national parliament composed of 2 senators from every estado. So the Senate will be the equivalent of the national parliament. And instead of having a lower house, we will elect the state parliamentarians. The state parliamentarians will constitute the parliament of the state. And also, we have to develop the two-party system so that we can have a majority among the elected officials. And with regard to voting, for example, the voting process in a constituent assembly, is it on every issue that comes up, or when we consider the Constitution as a whole, that we consider the separate voting? And
Once we agree on a separate voting or a joint voting. The matter of whether or not you vote in each section is a matter that you leave to the Constituent Assembly.
So every issue,
That's a matter for the Constituent Assembly to decide, not
No.
the resolution of both houses.
so 3/4 of the Senate, for example, we have to be considered on every issue.
Yes,
Well, okay.
as against the other system wherein the Senate will become irrelevant because the 3/4 will always come from the House.
That's worth thinking, Mr. Chair. Now, we have to strengthen the barangay system of justice.
Can we just, we are running out of time, Secretary Sitoy. Maybe first on the issue of whether or not we need to amend the Constitution, your position is that, yes, we have to.
Yes, we have to, and we have to go federal because
Yes.
of the proposal to revise the sharing of income, the national income, give more to the locals, to the Estado, to the state.
Having said that, are you in favor of a con-con or a con-us in effecting the amendment?
The more democratic way is con-con, but we are, if we are suffering from lack of funding and considering that we are after time, we can go con-us.
All right. Now, in case of a con-us, you're saying, what's your view on voting separately or jointly?
My view is we will observe separate voting only when the Constitution is considered as a whole.
Okay. But in the process of putting together that Constitution, it is your view that both houses should vote jointly.
Yes.
Can the Congress, when it passes the resolution constituting itself as a constituent assembly, can Congress impose limitations on the extent of the authority of the Constituent Assembly?
My humble view is that it cannot.
It has to be plenary.
Yes, Your Honors.
Thank you very much. All right. Thank you very much, Secretary Sitoy. Any other view that you wish to express?
I would like to go back to the judicial system. We have to strengthen the barangay judicial process.
Okay. Can we go back to that later after, if we still have time? I'll get the other views first on these 4 questions. If
Thank
you
you.
like.
Thank you, Mr. Chair.
Yes, Asek Aragon, would you have any input on these issues?
Your Honors, thank you very much. The Executive Secretary has spoken about the executive position, so the Department of Labor and Employment adheres to the position or based on the guide questions that you've posted, the 4 questions, in the spirit of tripartism, the concept of labor, employment, and government coming together for to discuss and really as a building block for consensus building in labor and employment, and harnessing our institutionalized consultative processes, sir, as created by law, where we have tripartite industry consultations. We have embarked on studies now as inputs to the matter at hand, whether to revise or amend the Constitution. We are studying right now, sir, policy issues that are quite important to us. For example, issues on linking wages and productivity and competitiveness for the labor force. We are also studying now the future of work with respect to, for example, trade unionism and collective bargaining and creating jobs and employment. So these are issues that are quite important. We have set a timetable up to the end of this year to finalize our, the studies and findings, and we will submit our inputs, sir, as one cohesive body. Thank you very much, Your Honors.
Thank you. Attorney Tulito, representing the Department of Justice.
Good morning, Your Honor. Good morning, ma'am. The Department of Justice, through this representation, Your Honor, has prepared a draft and it is submitted to my principal for signature. We subscribe the view of the Department of Justice is identical to the view of the Honorable Executive Secretary on the questions that is there a need to amend the Constitution? Yes, there is. What mode? We support the CON, as Your Honor. But the details of all of these questions will be are indicated rather in the written position paper of the Department of Justice, and I will submit that to the Secretariat once it is signed by my principal, Your Honor. Most probably not later than Tuesday, next week.
Thank you very much. Any other view?
Mr. Chairman?
Yes, Senator Pimentel.
You know, senators never run out of words, so if you will excuse me, I will just wind up with these few thoughts. Number one, Mr. Chairman, I would suggest we do not use the word con us, because that does not make, the members are no longer horses, but asses, you know. In other words, Mr. Chairman, let us be more careful with our words. And that is why, when we propose the adoption of the federal system, we are saying we create, not divide the country, create federal states out of the country, because we should be conscious about the effect of words that we are using. And then we want to stress that one of the major reasons why we have to adopt the federal system is the continuing concentration of powers in the hands of the Metro Manila government, in spite of the passage of the local government code, which is supposed to be revised every 5 years. You know that, Mr. Chairman. Has it been done? No, because the ones controlling the levels of power want to hang on to power. So they wouldn't want to touch, issues that would distribute powers to the federal states and to the local government units concerned. Now, finally, Mr. Chairman, I want to emphasize that the fear that some federal states might not be as capable as the others to sustain their own development, please note that in our proposal, we have espoused the theory that we should create an equalization fund, so that this fund will now be the agency which will, to which the federal states which are in need of help can go to. Much in the same manner that when we were a newly independent country, we used to run to the World Bank and the IMF, but these are alien agencies. In our proposal, we will put it in the revision of the Constitution that there will be an equalization fund for purposes precisely of helping federal states that may not be capable of doing so on their own, Mr. Chairman. Thank you very much, Mr. Chairman.
Thank you very much. Yes, Commissioner. Mabuhay po kayo.
I was just wondering, Mr. Chairman, Your Honor, whether a spectator can participate just for 5 minutes only.
Please, we still have, let's say we have 15 minutes. Please proceed. This is what we want to be a deliberative body, open to the public. Yes, please proceed. Just identify yourself for the record.
Good morning, Mr. Chairman, Your Honor, and Vice Chairman, Madam De Lima, and my good friend Nene, the Executive Secretary, my good friend Justice Mendoza. Good morning to everybody. You know what brought me here?
Before that, just for the record, that the Commissioner placed his presence or state on the record his name, please, just for the...
I'm former COMELEC Commissioner Manolo Bigorospe, a military officer before. I retired twice. And at present, I'm the Executive Vice President of the PhilConsa.
You're
It's just
speaking as Philconsa.
No, it's just unfortunate, Your Honor, please, that we were not invited officially. But when I saw when I saw
Philconsa was invited, just for the record. Yes, we
no,
sent it.
I don't know, but I only saw it in the television, Your Honor.
No. We sent an invitation to, who's the name? Who did we send it? We sent it to Philconsa, Attorney Romualdez, and Attorney Lazaro, for the record.
Well,
Maybe they did not inform you.
I was
Jose.
informed when there was a hearing during the congressional
But
but now,
we send it
I
to the
wa-
organization.
Thank you very much, Your Honor. But well, anyway, I came here because I love the Constitution. Perhaps nobody else could lay claim that even the framers of the Constitution probably have read the Constitution 300 times. Well, this was because of the call of the profession. I was former COMELEC Commissioner, and we have been using this. Well, by the way, one of the questions is there really a need to amend the Constitution? Before I answer that, Your Honor, please, Madam De Lima, we have already submitted our position paper. I think it was chaired by a certain Congressman Mercado. And just to be very brief, anyway, I have already posed this question to Justice Mendoza during our meeting last 3 days ago. Now, if you can recall, Your Honors, please, this Constitution, this 1987 Constitution, is one of the best constitutions that was ever adopted throughout the world. But there was one questions that we would like to pose. In the course of my being a member of the PhilConsa for the last 17 years, we went over the Constitution, and there are more than 100 provisions or sections which provides for, as may be provided for by law, as the Congress may provide, or until such time Congress will provide. Now, we went over this, there were only few, and one of those questions, like the anti-dynasty law. Alam niyo po, itong provision na ito, baliwala. For the last 30 years, there was never an attempt to implement what does a dynasty means. Now, one of the curious questions that was raised also, in the 1987 Constitution, it provided for even the salaries of the President of the Republic of the Philippines. And yet, from President Cory Aquino to President Ramos to President Erap to President Gloria Macapagal and lately President Aquino, there were never attempts to provide for the law that would increase. Why? Because the problem was, I think it was provided only for 25,000 pesos per month. Now, on the last year of President Aquino, they passed, I think, Your Honor's place, you passed a law increasing the salaries of President to, I think, 400,000. Simply because somebody probably might have told the president, former President Aquino, that if you retire, you will have to receive the last salary grade. I think it's salary grade 34, 35 or thereabout.
Commissioner,
Ang problema po dito,
Commissioner, I hope you don't mind. We intend to suspend this session in about 10 minutes in order
yes,
to...
yes.
If you can just put on the record your views on the 4 questions which we have discussed for the last 3 hours. Number 1, is there a need, in your view, to amend the Constitution?
Yes,
Number
yes,
2,
yes.
what manner or mode would you have preferred? Number 3, if you feel that the Constitutional Assembly is a proper mode, should we vote separately or jointly? And in your view, can you limit the powers of the Constituent Assembly or the Constitutional Convention? If you don't mind, we can expound on your other views in a subsequent hearing, but since we have only a few minutes... if you
Yes,
can-
Your Honor, but
Yes.
I was just going to the point.
Please,
Because of the failure of Congress to provide for all this as may be provided in 87.
Yes.
And so the question now is there really a need to amend the
Yes.
Constitution? Now, how can you amend a dead provision of the Constitution? How can you revise a dead provision of the Constitution? The 97 where Congress failed to provide for the enabling law. Because you can never violate the Constitution unless the enabling law is there. So it is our submission, Your Honor, that unless the 87 or rather 97 provisions which Congress failed to provide in the last 30 years, now the question is there really a need for us to amend the Constitution? And of course,
Is your answer yes
our
or no?
answer is yes.
Okay.
Yes, because actually I was about to submit na lang sana the
Sige.
the position taken kuan. Now as regards to the other issues raised, the Philippine Constitutional Association has been very supportive in everything. Like the one that was already discussed by Senator Pimentel, I think we were the first one who held that symposium in Polo Club. Can you remember that, Senator? So those are all the things that we would
Thank
like. Unless, as I've said, Congress will have to pass all this as may be provided for by law, as may be, I think there is no necessity for us to amend the Constitution if in the last 30 years, by gum, what will happen?
In other words, you should let Congress perform the mandated task under the present Constitution, and there will be no need to amend the Constitution.
Probably that would be the best solution, Your Honor.
Thank you, yes. Okay, thank you, Commissioner, for your very...
Just for the record, since we have already submitted our position paper with
Yes.
the House, probably if there is a need for us to submit it before
Yes.
this committee, we will do so.
Thank you very much. It's already 5 minutes past 12, and my mentor, Senator Pimentel, is giving me a dagger eyes already, so we are about to suspend our hearings, and we will call another hearing because there are a number of other resource persons who could not make it today. Particularly, for example, former Con delegate Christian Monsod. He has requested that he be given an opportunity. And also former Justice Natsura, and we have a few other constitutional experts. So with that, we now suspend these public hearings. We will reconvene sometime in January And we will call hearings initially in Baguio, in Cebu, and in Cagayan de Oro, in addition to more hearings, at least one or two more hearings in Manila. We take note of the suggestion of Senator Pimentel that we should add more out-of-town hearings. Thank you very much, and the session, the hearing is suspended, and we will notify you of the next meeting. Thank you very much.
Thank you, sir.
Thank you. Nice meeting you po.
Lunch will be served. It's